There you are. Welcome.
Thank you, Your Honor. My apologies.
Oh, no problem. At some point during this OA, I guarantee you I will start speaking with my microphone off. So it's normal. Okay, Mr. Isaac, you're up.
Thank you very much. Good morning, Your Honors. May it please the court. My name is Ilan Michael Isaac, and I represent the petitioner, Eugene Zenko. Your Honor, I'm going to ask for a 5-minute heads up if that's okay. I'm before the court this morning on behalf of my client. It is a petition in second-tier certiorari from a driver license hearing. I recognize that second-tier certiorari is a very limited level of review. Oddly enough, I do believe that we are entitled to second-tier relief, not only because the circuit court impermissibly reweighed evidence and made its own factual findings, not made by the hearing officer and certainly not supported by the evidence, but the circuit court failed to apply the correct law. And in doing so, there's a fairly recent case out of the first DCA called Taylor that I provided supplemental authority to the circuit court. They struck it. But nevertheless, instead of relying on Taylor, the circuit court cited to the case of Dermio. So I believe that we're entitled to certiorari relief in both instances, on both grounds. In looking at the particular facts, as I pointed out in my petition, the hearing officer made findings of fact that were specifically found on page 3 of that final order, and those facts were the petitioner was very confused upon waking up, had difficulty responding to the request for him to roll down the window, and had dexterity issues trying to accomplish rolling the window down. The petitioner
Mr. Isaac, can I interrupt you?
Yes, ma'am.
Because I think the facts, you both laid them out beautifully, and I think
Okay.
they're out there. Help me out because of the second-tier cert, and I know you briefly addressed it. Let's focus more on that. Let's just assume that the hearing officer was totally incorrect in his findings. Let's just assume that the hearing officer, based on the facts presented, shouldn't have come to the conclusion that he did, that, that there was no, let's just assume that was the case. Then it goes up to second-tier, it goes up to the circuit court. And the circuit court basically, in this case, they go along with, what is it about when you said it was a departure? What did the circuit court do in its appellate capacity that gives us, because second-tier cert, like you said, is an extraordinary remedy. So even if we assume factually, legally, you are correct, how do we get around the very stringent requirement of the second-tier cert?
So the circuit court made a finding that my client voluntarily opened the door. The hearing officer never made that finding. The hearing officer found that my client just opened the door. In fact, in his order, in one place, he said the petitioner eventually opened the door. And then 2 pages later, during a discussion of one of my motions, the hearing officer said the petitioner on his own opened the door. The petitioner didn't, the hearing officer didn't say the petitioner voluntarily opened the door, just on his own. And there's some context to that. And that's why I said in my petition, or in my argument, voluntariness is not synonymous with on your own. The Merriam-Webster definition for on your own means without aid or support. The facts are unquestionable. The officer kept knocking and knocking and knocking. He kept ordering my client to roll down the window. My client was having difficulty doing that. The hearing officer, when he makes the finding that my client had dexterity issues, but on his own opened the door, it's in response to the fact that he couldn't on his own without aid or support roll down the window, but he did open the door without aid or support. So the context in which that statement is made by the hearing officer is not voluntariness. So in the circuit court order, the circuit court misinterpreted that phrase on his own. And they came to the conclusion that that means it's voluntary. They made a finding of voluntariness, They're not permitted to reweigh evidence. They're not permitted to make factual findings on their own. That's impermissible. That's impermissible reweighing of evidence. And that's exactly what the circuit court did.
So by virtue of the term on his own, it could be interpreted two different ways, not on his own that he did it because by his, willingness on his own, which would equate with voluntariness. You're taking the position he did this on his own because he did not need assistance when he did ultimately open the door. Is that what you're saying?
My argument, you're correct, but my argument is supported by Merriam-Webster. The definition, the context and the use of the phrase on your own is synonymous with no aid, no support. And as this court knows, words matter. When the legislators pick the wrong words, they may have intended one thing, but the words have a different connotation. The hearing officer, who by the way is a lawyer, if he wanted to make a finding of voluntariness, he would have done it. He would have said, the officer asked the petitioner to roll down the window, but instead he voluntarily opened the door. The hearing officer never came to that conclusion, never. And that's why I'm saying in the context of reading that one statement on page 4 of the order, where it writes, after Officer Barlog knocked on the window, petitioner was very confused upon waking up and had difficulty responding to the request for him to roll down the window. Petitioner also had dexterity issues trying to accomplish rolling down the window, so he, on his own, opened the driver's side door. The context there is he's having difficulty, he needs aid, he needs support to roll down the window, but he doesn't need aid or support to open the door. The context of the meaning that consistent with Merriam-Webster is right there. When you look at the statement in total, the circuit court just misinterpreted, and they came to the wrong conclusion. They misinterpreted what that statement apparently means, that it's voluntary. The hearing officer never made a voluntary factual finding, and the circuit court on appellate review and first-year certiorari was certainly not allowed to make its own factual findings now for the first time. That is impermissible reweighing of evidence.
Mr. Isaac, looking at Taylor, is not that case easily distinguishable from the instant case in that in Taylor, the operator's vehicle, the ignition was off, the car was not running, and here the car is running, which gives at least the element of being in actual physical control being present. Isn't that an element of DUI, being in actual physical control?
Oh, absolutely. But
Right.
with all due
So
respect,
he's in actual physical control when the officer comes to the window and knocks on it to make sure that he is capable, in light of the hearsay evidence that the dispatcher received, if we can call it that, to go there, to make sure he can operate this dangerous instrumentality. So he rolls down the window. Does he not then indicate in the officer's testimony he got a smell, the odor of alcohol?
well, with
He
all
asked
due
the
respect,
gentleman to step outside the car, and we have staggering. Aren't some of the reasons for probable cause being met, which would then support a suspension?
well, with all due
What
respect,
does it
Judge,
matter whether he voluntarily or involuntarily rolled down the window? I guess is my point.
well, with all due respect, Judge, I don't mean to cut you off.
No, you're fine. Please, I
Okay.
wanted to hear your answer.
So what you're talking about is whether or not my client who's sleeping in a lawfully parked car can have interaction with law enforcement. That's not the consideration here, because the evidence was that this was a community caretaking function. Consistent with Katie versus Dombrowski and its progeny, the criminal investigation that you're referencing has to be completely divorced from any community caretaking function.
So the officer testified he was doing a wellness check, basically.
Correct. That's right in the report.
And once he got the surfer signal, at that point, there was no reason to proceed with the wellness check.
And
Well,
in
it's not-
fact, didn't he go like twice? So if
He
in
did,
fact
he
it was
did,
just
did he?
purely, even if it's purely a wellness check, first time he gets that signal, and then he did it again, and at that point he gets a thumbs up, like I'm A-okay. So if it's purely a wellness, at that point that stops. So
I agree
anything
with you. And
after,
that's,
so let's just, if that's the assumption that we're making, then from that point, anything afterwards, the officer, if it's pure wellness, he gets not only the surfer, which, in the surfer, I didn't know that the surfer means I'm A-okay. I just thought, hey, cool, I'm here,
So
But
once he says to the fellow to roll down the window, that's a
Then-
detention.
then that's split second is your argument is after he gets the surfer, then the second time with the thumbs up, then at that point he should be done. The officer should have left because he's A-okay, but then he went further and then we said to roll down the window.
I don't want to cut any of your honors off.
No.
Okay,
I'm
so-
just.
so-
Why don't we argue your case for you?
so I agree. And in response to Judge Casanueva, the Taylor case talks about the justification of the community caretaking function, but the moment that the reason, the legitimate concern for well-being is resolved, that's the end of it. So yes, so my client makes a gesture like a surfer gesture, which maybe could be interpreted in a number of ways. It could mean he's okay, but it could mean other things. But when he gives a thumbs up, everybody on this panel knows, as well as my opposing counsel, nobody's going to misinterpret a thumbs up. My client said he's okay, and consistent with Taylor, that was the end. But the officer keeps knocking and he keeps asserting himself. And that's why I made the argument that Dermio was not the applicable law. And actually, I see this case perhaps as an opportunity for this court to discuss the limitations of Dermio, because while I respect the ruling, whoever litigated Dermio, unfortunately, didn't raise the nuances that should have been raised. They didn't raise knock and talk and the implications of knock and talk, and they certainly didn't raise police-created exigency. And to that extent, I think that for Dermio to represent the rule of law that anytime police knock on a window and the person doesn't respond, it justifies an entry into the vehicle out of a wellness check would be inconsistent with Kentucky versus King and the limitations of police-created exigency, because it is, in fact, that knocking that's creating
Well,
the exigency.
let's come back.
Okay.
There's a report from, I think, person on their own. It's unclear to me whether the police have the identity of the person who called in. I don't recall. If there was
It's anonymous.
it's an anonymous call, and it's this fellow is in the parking lot. He's kind of, I don't know. I'm going to use the word stumbling, but kind of stumbling around, and he urinates on the car. And the officer who responds knows those details, correct?
Does.
But he doesn't know who made the call.
Does not.
Citizen informant, but it's anonymous informant.
It would be
I mean,
an
if he-
anonymous tipster. Yeah.
If he could act on those facts, I mean, wouldn't he have reasonable suspicion that this fellow was intoxicated?
Well, but that's why I actually go through and I
And
do
he's
that.
sitting in a running car, I mean,
That's why I do that analysis in my petition about the nuances associated in somewhat of a Popple-esque form.
Popple-esque, I like that.
The different nuances and what the officer would have to do in order to justify entry into the car. That's why I said I think this case is actually a good opportunity to discuss the fact that Coniglia versus Strom came out and said community caretaking has been used, unfortunately, over the last 50 years since 1973 as a standalone exception to the warrant requirement under the Fourth Amendment, and that's the incorrect use. Justice Alito made it very clear community caretaking was never intended to be used as that function. And now you have, subsequent to Coniglia versus Strom, you have the Taylor case, which further discusses the limitations of community caretaking. So with all due respect to the rule of law that happened as a result of Dermio, it's overbroad. And now I think the court has an opportunity to scale back and to actually now, because I correctly raised those issues and made those arguments, which were never made in Dermio, so the court never addressed it. But now the court has to address it. And since they weren't argued and addressed by the court in Dermio, Dermio is not the applicable law on those particular nuances. Coniglia versus Strom is, Taylor is. and Kentucky versus King and all those other cases that I cite you. That's where this court's going to get the instruction as to whether or not, given the facts in this case, whether it was justified. I
Well,
submit it was
coming back to our second tier cert
Okay.
standard. Okay, if we're going to pinpoint where the circuit court, strayed from, the correct, applying the correct law, I suppose. It would have to do, and correct me if I'm wrong, but I'm getting, it would have to do with its declaration that Mr. Zenko's opening the door was voluntary with its legal implication.
That's true. That's
That
true.
and that's it. And
I agree.
you point that the court engaged in improper fact finding.
That certainly is my strongest argument.
Okay.
Absolutely.
Could it also be characterized? Because voluntariness in these cases is really, it's kind of a mixed question of law and fact, is it not? I mean, we look at the facts. The trial court might say, "Oh, this is voluntary," and we look at the facts and they say, "Oh, no, it's not." I mean, that happens all the time in these cases.
Okay, but I think
So in this case, though, couldn't you characterize what the circuit court did as looking at the facts as determined by the hearing officer and declare that was he voluntarily opened the door as a legal matter, and so really it becomes a question of whether that's a legal error.
Well, no, but that's not the context in how the circuit court used the voluntariness. It was a factual issue, not a legal issue. They made the determination that whatever happened was because whatever observations they made was based upon the fact that he voluntarily opened the door. That's a factual question, not a legal conclusion. It might in some instances be both, but here the circuit court used it on for the premise that factually, and that was improper reweighing. And I think that going back to our days of law school, the classic but-for test, is applicable here. But for this officer knocking and refusing to take my client's thumbs up,
Right.
my client never opens the door. My client only opened the door because the officer kept knocking and kept asserting that show of authority. There's no indication in the evidence that my client, but for that knocking and persistent knocking and the officer refusing to accept his thumbs up, my client would have opened the door.
Mr. Isaac, you're into your rebuttal time. So
Okay, then I'll thank you, and I'll wait to address
give Ms.
the
Jones a
moment.
chance. All right.
Sure.
Okay, Ms. Jones, you're up. Your turn.
Good morning, panel members. May I please support? My name is Alana J. Jones. I represent the Department of Highway Safety and Motor Vehicles. And of course, as is stated earlier, it's important to remember what our standard of review is on second tier cert. And of course, was procedural due process afforded, which is not an issue in this case, and was the correct law applied? And determining whether that's the case, it has to be determined whether there was a violation of a clearly established law resulting in a miscarriage of justice. And in this case, that did not happen.
How about Ms. Jones, Mr. Isaac's position that the court did engage in improper fact finding? The appellate court did, when we're talking about the circuit court in its appellate capacity,
Yes, ma'am.
by virtue of injecting the word voluntariness in opening the door. And his position is, by that term, voluntariness, that the court, in fact, came to the conclusion that they interpreted it on his own, that it was done in a voluntary fashion. How do you respond to that?
Well, Your Honor, my response would be looking at the context as well, looking at the context of what happened. When you look at what the hearing officer says, how Officer Barlog knocked on the window, he notes that the petitioner appeared to be very confused upon waking up. He had difficulty when he was requested to roll down his window. He had difficulty operating the controls. And as a result of those dexterity issues, he on his own opened up the door. The court was not pulling out of the sky voluntariness. He's looking at the fact that this individual, while confused He's in a state where he's having difficulty rolling down the window, which he's willing to do. He's now on his own or voluntarily opening up the door. This is absolutely susceptible to different interpretations. And this is a reasonable interpretation that he voluntarily opened up the door given the context of what is happening. So no, the court is not reweighing evidence and pulling out of the clear blue, oh, he voluntarily opened up his door. No, he's looking at the context of this gentleman trying to respond in a confused state, being unable to operate the window controls, and then voluntarily or on his own opening up the door to speak to this officer. So no, this isn't a reweighing. This is merely, okay, sure, were different words used? Yes, but when you look at the context, it's the same concept and it's consistent with what the hearing officer said.
Okay, and then let's go back to the facts in this case.
Yes, ma'am.
You agree with Mr. Isaac that the officer's testimony that he was there to conduct a wellness check. We all agree. This is let's just call it an undisputed fact. You agree with that, Ms. Jones?
Sure, he stated that
Okay.
he had a medical concern for
Okay,
the petitioner.
so he comes up to the car, and as Judge Northcutt indicated, the car was running, but it was parked. It was parked, and he saw what appears to be an individual, either asleep or slumped over. And so when he knocks, yes, the person wakes up and then gives that surfer sign.
Mhm.
Okay.
Yes, ma'am.
So the surfer sign, okay, let's just assume that maybe the officer did not know. I mean, I didn't realize the surfer sign that I am A-okay. I just thought, hey, man, I'm cool or whatever, but I'm not A-okay. But then
You're not much of a surfer, are you, Judge?
I'm sorry, Judge Northcutt. I must have missed that. But anyway, so the next step, Ms. Jones, and when he does it again, then this time he gets a thumbs up. So
Okay.
the thumbs up, in a way, I agree with Mr. Isaac. There's no question, thumbs up, like I'm A-okay. Why at that point, once the gentleman said, I'm A-okay, why doesn't it stop at this point in time?
Okay.
Because then he persisted, and when he persisted, that's later on the issue of dexterity, the issue of on his own and all that. But don't we have a clear line at that point once he gets a thumbs up that that's it? He's A-okay. Granted, the car is running. Granted, he's lawfully parked, but he gets a thumbs up.
Well, Your Honor, I would respectfully disagree with opposing counsel's view that the thumbs up sign in that instance necessarily meant I'm A-okay. The thumbs up sign could mean anything in any given context. When you look at the facts in this case, after being requested to roll down the window, that's when he puts up the thumbs up sign. Your Honor, that could mean, okay, I'll roll down my window, but he doesn't comply. And this is within the context of him still being confused, still being out of it, and the officer still having a concern for his welfare. So the thumbs up sign in that instance does not necessarily mean I'm A-okay, leave me alone. I would posit that can have any number of meanings given the situation. It could mean hello. It can mean, okay, I'll roll down my window. It could mean I'll be okay, I'm okay. But even him giving up the thumbs up sign in isolation doesn't necessarily end the welfare check if his concerns are not allayed or dispelled. If he still sees that this person is confused, if he still sees that this person is out of it, it doesn't dispel his concern. There have been instances where people have said overtly, I'm okay, and instances where objectively they were not okay. So the person in that instance didn't stop proceeding to help them, they still proceeded to help the individual. So those signs in and of themselves do not indicate that the community caretaking function stopped at that point. Furthermore, it should be noted, Your Honor, or for this panel, that community caretaking based on DeShong can be based on a concern that the person is ill, the person is tired, or the person is impaired. So it could be any number of reasons why a community caretaking function is conducted. And this point is made by counsel and has been discussed in this panel that, oh, he stated that he had a concern for he had a medical concern. That's why he was doing the welfare check. However, the case law indicates that there doesn't have to be an overt statement that there was a medical concern. As a matter of fact, an officer can state that they weren't concerned about their welfare and it still be justified as a wellness check. And that's found in Tripp versus State. That's 251 Southern 3rd, 982 in the first DCA. And I didn't include that in my response, but I thought it was important to address at this point. It's an objective test that's made when you're looking at these situations. You're not limited to, oh, I said it's medical, so therefore I have to hold on to that. No, it's an objective test. Was there a reasonable basis for the reasonable officer seeing the circumstances that were happening at the time? Was there a basis to conduct a welfare check? And in this case, there certainly was. And those signs that were given did not dispel the officer's concerns. He still appeared to be out of it. So the correct case was applied, Dermio. Dermio was absolutely appropriate. As a matter of fact, the facts are substantially similar to the ones in this case, as the court, I'm sure, knows. And it's also important to note with regard to Katie versus Dombrowski. The statement has been made, Katie versus Dombrowski states that you can't have any, basically the statement's being made, you can't have any suspicion of impairment, or it has to be totally divorced of suspicion of impairment. That's what Katie Dombrowski says when you have a wellness check. But that's not what that case says. What the case isn't stating, in Katie versus Dombrowski, it makes the statement that community caretaking functions are totally divorced from the detection, investigation, or acquisition of evidence. What the court is saying in Katie, they are making a distinction between what's required for a wellness check, a stop for a wellness check, versus what's required for a stop if there's a suspicion of criminal activity. That case does not state that you can't have a suspicion of impairment. There's nowhere it states that in the case. It's merely saying, hey, if you're conducting community caretaking, you don't have to have reasonable suspicion to stop someone. That's the context of that statement. But again, Deshawn states that if you want to check you can check a person if you suspect that they're ill, tired, or impaired. And that's what was done in this case. And of course, Tripp again says you don't even have to state that you're conducting a medical check or a wellness check. If the objective facts give rise to a basis for a wellness check, you have a proper stop. Now, with regard to the Caniglia case, which was mentioned by opposing counsel, that case does not stand for the proposition that community caretaking has been misapplied as to the facts in this case. In Caniglia, you had a situation where an individual was consented to a wellness check because he was allegedly suicidal. And while he left his home, the officers went in and took his weapons. And they used community caretaking as a basis to enter the home. And the court made the distinction, hey, this is not a freestanding doctrine to be applied in any setting. And the court goes on to state that this community caretaking doctrine is not to be applied to the home where you have to have a warrant. It wasn't saying that it wasn't applicable to our situation. This situation, it's absolutely appropriate. So Caniglia really doesn't even speak to the issues in this case. Similarly, in Taylor, Taylor, you do have the stop of a person who is sleeping in his car with a knife in his lap. But in Taylor, there was no effort to ascertain whether the person was well. There was no effort to knock on the window. As a matter of fact, there didn't seem to be any concern for the person's well-being. There was no attempt to rouse the person. They just opened the door, went in, got the knife. There's a K9 circling the car. He smells drugs. They go in and search and they find drugs or and paraphernalia, and then they go forward from there. Those aren't even the facts of this case. So Dermio is absolutely the appropriate case to be applied. With regard to the arguments made by counsel concerning why Dermio shouldn't be applied, because these arguments, the police created exigency argument wasn't raised in Dermio, and the knock and talk doctrine wasn't applied. That's beyond the scope of this court's review. First of all, these doctrines, or the argument of these doctrines, don't change the basic issue in Dermio, which is the same issue in this case. The issue in Dermio was there an unreasonable search and seizure which violated the person's Fourth Amendment rights? And that was exactly the issue. That was the subject of the motion that was at issue on appeal in Dermio. Likewise, counsel is making the same argument. He's using different doctrines to come to that argument, but it's the same argument. Is there an illegal search and seizure? And was there a violation of the Fourth Amendment constitutional rights? Furthermore, it's beyond the scope. What the court did below, the circuit court, they determined, based on the facts, that there was competent substantial evidence that the petitioner opened his door voluntarily or on his own. That was a finding made by the court. The court found there was competent substantial evidence for that. As a result, we don't have a discussion at this point concerning factually whether there was a police created exigency. The court decided that issue when they found that there was competent substantial evidence to support the fact that the petitioner opened the door on his own or opened it voluntarily.
I think, Ms. Jones, as I understand Mr. Isaac's argument, is that at the point, in fact, when he opened the door, as I hear Mr. Isaac saying that was well after the officer was given a signal that Mr. Zenko was okay, that by virtue of him being persistent a third time to still pursue to have him open the door, that at that point that crossed the line, and that became intrusive, that became, so all the case law, and not to use, the case law as a vehicle, to basically, without a warrant. And so I guess the question for us to determine is to look at the facts as presented, to look at it, the sequence, not to jump to the fact, oh, he opened the door voluntarily.
Absolutely.
At the beginning, okay, so you had one knock, and then he gets a surfer sign. He gets another knock, and this is where, and then it's interesting, is it your position that when the officer was telling him to roll down the window, that the thumbs up was done in response to that request, as opposed to the thumbs up saying, I am A-okay?
That it was after the knocking on that window, the second time, you get the thumbs up sign. So what does that mean? Okay, I'll open up the window. Okay, it could mean anything, Your Honor, and that's why the fact finder at the administrative level reached the conclusion that this was an appropriate interaction with the officer because his concerns were not allayed.
Let me ask you this, Ms. Jones. Let's just assume the following facts. Knock number one, he gets something that's not quite right. After knock number two, and if the defendant would have said, I am A-okay, at that point, would the officer be justified in leaving? Or under your argument that because it's objective, he hears I'm A-okay, that he still has to pursue to find out?
I'm sorry, Your Honor.
No. I'm just trying to find out, where do we go? And is there a line to be drawn until such time? When does it become objectively, even if you have a defendant saying, I am A-okay? Does that justify him keeping on?
Well, based on the context of this case, Your Honor, it does appear that it was justified for him to continue to knock because he was still confused. there's no indication that that confusion of the driver had somehow dissipated. The officer didn't indicate in his report that, oh, now he was clear-headed, he was coherent, he was able to speak.
So like if you took a like a more extreme hypothetical, if he's sitting there with blood running down his face, but tells the officer, I'm okay. At that point, you're saying the officer doesn't have to take the person's word for that in terms of,
Of course, now, of course, and that, of course, as you said, that's an extreme.
but this is a more nuanced
Absolutely.
situation, but the principle would still apply.
The same principle applies. Exactly, Your Honor. Just because someone says they're okay, and again, it's debatable whether that thumbs up meant I'm okay. I mean, that was something for the fact finder to find at the administrative level. The circuit court found there was competent substantial evidence for that finding of the fact finder. And certainly at this point, we're not in a position to debate that point. The question, the issue is the officer's concerns were not allayed, which justified him going forward, which is in keeping with Dermio. So the officer, and again, we have to consider the whole context. As Your Honor Northcutt stated earlier, this was a gentleman who was reported to have issues going to his car. He had trouble struggling to get to his car. He urinated on the car. He's in a parking lot, car running, 7:30 in the evening in a bank parking lot in a tow-away zone. I mean, all of these factors are not favorable factors, and these are things that are lending to the concern that this officer has. And there's nothing in the evidence that indicates that that concern was allayed by the actions of the defendant or anything that he said, and certainly not by the, at best, equivocal signs that he's giving in response to the officer. It could be argued that those responses were non-responsive responses. So the officer looking at this situation was justified in going forward to determine what is wrong with this individual, what's happening with this individual. And then, of course, we get to the point where the door opens and then eventually the indicia of impairment are observed. And it's important to note that this doesn't turn into an investigation at the point of the knocking, at the point, even when the individual opens up the door, even when he on his own voluntarily gets out of the car. Once the officer observes the indicia of impairment and sees the bloodshot eyes, the flushed face, the swaying, and so on and so forth, the point where it turns into an investigation is when the officer finally says to him, I would like you to submit to field sobriety exercises. That's when it becomes an investigation, a DUI investigation at that point, not at the point of what has been termed as persistent knocking. The knocking continued because the concerns weren't allayed.
And Ms. Jones, you are at the end of your time.
Thank you, panel members, for your time.
Thank you very much. Okay, Mr. Isaac to rebut.
I
And
can't,
Mr. Isaac, I know you're itching to respond because I could see based on your expression, but help me out with one thing.
Okay.
How do you respond to Ms. Jones' statement that when the second knock, when the officer was asking to roll down the window, he gets a thumbs up, and that could be interpreted by the fact finder to be in response to that request, that yes, thumbs up, trying to open the window, not able to open the window?
well, her interpretation was not any factual findings that were made by the hearing officer. So she's now asking you folks to make factual findings that the hearing officer didn't make, which is something you can't do either. You can make it, you can certainly draw natural inferences, what is a reasonable inference, but what she's asking you to do is impermissible as well. And a thumbs up is universal. I'm okay. So I'm not asking you to do anything other than to
Well, I don't know, Mr. Isaac. It could be, hey, I hear you. I'm working on it. You know, don't rush me. I mean, it can be, I'm okay. Can be, hey, I hear you. I heard you.
So, well, I think that the natural the natural inference or the logical inference is I'm okay. I disagree with Ms. Jones' interpretation. I don't think most people think that that's what it is. And I'm going to ask your honors, when you first read this and you saw a thumbs up, what was your first inclination? I'm okay. I think that's the way people interpret it. So, but I think
Why
that
does
what Ms. Jones is doing,
representation of being okay become one, the veracity of the investigation and binding on the police officer at the scene in terms of doing the community caretaker?
I'm sorry.
Why does that become dispositive? I mean, most of us have seen people in DUI cases before, or I'm fine, I'm telling you there's no problem. They go staggering all over the line. Why is it that because he puts up in whatever form, that becomes dispositive to the police officer and causes the investigation or the community care check to stop? Because the language of the Taylor case talks about the welfare of not just your client, but the welfare of the citizenry at large. So my concern is, why can't the officer keep going, even if he puts a thumbs up 3 times to verify?
He can. However, that's why I go through that discussion, the different nuances. What the officer could have done at that point is look inside the car and whatever he can see in plain view. Does he see open containers? Does he see drugs? Does he see chemical substances?
Okay.
Does he see injury? Are there liquids? Is there blood? Is there trauma? Is there a gun? Is there a knife? Anything that's in plain view, he can objectively look at the context and the circumstances to see what's happening. But that's not what he did here. All he did, instead of walking around the car, instead of seeing what he could see, all he did was continually knock, knock, knock. And after my client gave a thumbs up, he refused to take that acknowledgement. And one of the cases that I cite to, the Brown case.
Well, does he
Is
have to
an
take no
instance-
for an answer?
I'm sorry?
Does the police officer have to take no for an answer under these circumstances?
If the car
Which
is
is
lawfully
effective,
parked,
I'm okay.
if the car is lawfully parked, then yes, because
Yes, but this car has the engine running, and that means the driver is in the actual physical control of the car, which is an element, depending on investigation, which may lead to it. So he has a dangerous instrumentality there, and he wants to make sure this person is okay. And it sounds like what you're arguing is the minute that person says, hey, thumbs up, the wellness check stops. I'm not sure that's what the law says. That's my problem with the analysis so far. And Taylor talks about finding drugs in the car, that they totally, no problem, the guy was sober and the car was not on. I understand the argument, but I'm not sure Taylor gets us there by itself. And what you're telling me, I look at Katie versus Dombrowski. Katie versus Dombrowski, the car was in a police impound lot, right?
Yes, sir.
And the other case is going into the sacred Holy of Holies, the house. So I'm trying to make sure I navigate through all these cases to determine whether or not the standard of review that the trial court departed from the law in a material manner that creates harm. I'm not sure I'm there yet. That's why I want you to tie it all together for me.
Well, before you take too much time, Mr. Isaac, I'll point out that you and Judge Casanova have used up your time, so I'll let you.
Okay, I'm
wrap it
sorry.
up.
I'm sorry, then I'll withdraw the question and you don't have to worry about it.
I would
I'll
very
read the
much
brief
like,
again.
I would very
It's up
much.
to the chief.
I'll
I
let
have
you
permission
finish
to
up your
answer?
thought. Yeah, but go right ahead.
Thank you, Judge. So Judge Casanova, just because my client is sleeping in a lawfully parked car, what is he doing wrong? Are we going to suggest that simply because somebody?
This didn't start out as a wrong. This started out as an investigation to make sure he was well.
I understand that, but once my client gives a thumbs up, he's sitting in a lawfully parked car in Florida. It's not unreasonable that people would have the car on so that they have air conditioning. Are we going to suggest that simply because law enforcement finds somebody in a car that's lawfully parked with the engine on, that justifies continued knocking by police to say, I want to check on you, even though you gave me a thumbs up. I don't want to accept your declaration that you're okay through your thumbs up. So I'm going to continue to knock and knock and knock and give a show of authority to force you to come to give in to my shows of authority so that I can verify and I can be secure in my notion that you're okay, even though objectively I can see into the car and I don't see anything wrong. I don't see illegal substance. I don't see open containers. I don't see any injury to you. I don't see dangerous instruments to you. Objectively, I don't see anything other than a person sitting in the car.
Okay,
That's
at this
running.
point, I'm gonna call the game. So
Okay, thank you, Judge.
thank you both. Very,
Thank
very
you. Thank you.
well argued case.
Very,
And
very
in-
well
in order-
argued.
In order to leave the virtual courtroom, there is a button on your Zoom screen. It's called leave. And if you click that, you will leave.